Again, Madam Deputy Speaker, thank you very much, and thank you to all the right honourable members who've participated again. Amendment 2 relates very centrally to the core of this bill, which is about the question of the setting of tariffs. And we've discussed this, Madam Deputy Speaker, with a great deal of verve and vigour from many different sides. The first debate, Madam Deputy Speaker, that has taken place in the last hour and a half has been, of course, around the purpose of these tariffs, why we're doing them in the first place. Why we're doing them in the first place comes out of a perception of an anomaly. That anomaly can be seen either, as the Honourable Member for Bexhill and Battle pointed out, in terms of the fact that the number of car crashes, Madam Deputy Speaker, is coming down and cars are getting safer, but at the same time the number of whiplash claims over the same period has increased dramatically. Or the anomaly could be perceived, as the Honourable Member for Spelthorne has pointed out, in terms of national differences. So many more whiplash claims, for example, in Britain per head of population compared to Germany or France, leading to the Honourable Member for Spelthorne speculating on biological differences. The second type of argument, of course, that has been made has been the arguments around proportionality, and these have been arguments made, for example, by the Honourable Member for Middlesbrough South East and Cleveland. He's essentially arguing, along with the former President of the Supreme Court, Lord Brown, that there needs to be a closer relationship between the amount of the compensation paid and the nature of the injury suffered. As Lord Brown said in the House of Lords, lesser injuries were altogether too generously compensated, certainly in comparison to graver injuries. Right? So this idea of proportional compensation for a type of injury was central to the argument of Middlesbrough South East and Cleveland. Honourable Member for Dudley South reminded us both that the former Labour Lord Chancellor, Jack Straw, had serious concerns about compensation for soft tissue industry, and reminded us also that this form of car insurance is in fact mandatory, putting a particular obligation on the House of Commons when thinking about it. But characteristically, the most sensible, proportional, calibrated speech came from the Honourable Member for Cheltenham, who, by using those three adjectives to define the nature of the tariffs, brought us in a huge move from jurisprudential reflections on the nature of tariff systems right through to a disquisition on rural transport in Cheltenham. The Honourable Member for Stoke-on-Trent South brought it down to earth with a good focus on safety in vehicles. Yes?
I'm very grateful. I couldn't resist letting the Minister move on from my honourable friend, the Member for Cheltenham's very important and significant points. But one of those he did emphasise was the role of the Lord Chancellor in consulting with the Lord Chief Justice in the setting of the tariffs. That is an important safeguard. Can the Minister tell us a little bit more as to how it is envisaged that that will work?
Well, absolutely. The first thing to say is that this is a concession which we've inserted in the bill, partly due to pressure from the Honourable Member, the Right Honourable Member, the Chairman of the Justice Select Committee, and from other members here in the House, including the Honourable Member for Cheadle. This means that in moving forward, the Lord Chancellor, in a judicial capacity, reflecting on the nature of the tariff, will consult with the Lord Chief Justice. That amendment, or that concession in the bill, combined with the strong emphasis on judicial discretion, allowing them to uplift the tariffs, is going to be central in our attempt to reconcile a tariff-based system with the tradition of English common law. And we hope through it addressing some of the concerns raised by the Right Honourable Judge Lord Wolfe. In general, therefore, if I can make a little bit of progress, Madam Deputy Speaker, we've discussed a great deal the purpose of this bill and the way in which getting rid of the tariffs in the way suggested in Amendment 2 would undermine the central purpose of getting a more affordable system into place. We've made a number of concessions in order to meet some of the concerns raised by many distinguished colleagues around the House, including individuals who both have personal experience of personal injury law and also experience as constituency MPs, the very honourable and serious work done by personal injury lawyers. So just to touch on some of those concessions and to show respect for the House, the first of those is that, of course, in the initial proposals put forward by the Chancellor of the Exchequer in the autumn of 2015, the suggestion was that there would be no general damages payable at all. This is roughly the argument that was made by the former Labour Lord Chancellor Jack Straw. We've moved away from that position. We've accepted that general damages should be paid, but have instead suggested that there should be a tariff for those damages. A tariff where, as the Right Honourable Member, the Chairman of the Justice Select Committee, pointed out, we will consult the Lord Chief Justice, where there will be judicial discretion. There is a precedent on tariffs, and that precedent, of course, exists in Italy and Spain, and there is indeed even a precedent within English common law in the Criminal Injuries Compensation Scheme. The benefits that a tariff system, we believe, will deliver are not only a reduction in the costs of this form of transaction, and hopefully through that a reduction in the number of potentially exaggerated or fraudulent claims coming forward, and therefore an advantage in terms of general public honesty, not encouraging people to make fraudulent claims, but also providing certainty and predictability to claimants, particularly when connected to an online portal, which will make sure that you follow the following sequence, Madam Deputy Speaker. Proceed to the online portal, then go for the first time, required to go to a medical practitioner who would specialise in whiplash claims, who would then give you a prognosis of 6 months, 12 months, 24 months. On the basis of that prognosis, then through the portal, to have a fixed tariff which would tell you exactly how much that you were given for this. This should mean that in the overwhelming majority of cases there would be absolutely no requirement to proceed to court at all. In the case where we did proceed to court, we would then be relying, of course, on the small claims process in order to settle it, but again, with the tariffs to reinforce. Now, if I can take a second, Madam Deputy Speaker, because we didn't touch on this in the speeches so far, just to touch on Government Amendment 1, which I hope all members, including members of the opposition, will be happy to accept. Government Amendment 1 relates, if for those who look at Civil Liabilities Bill, if you look at page 5, section 7, A says, in relation to one or more whiplash injuries, the amounts specified in the respect of the injury by regulations under section 3.2. And Madam Deputy Speaker, were you to return to section 3.2, on page 3, line 25, you would see the amount of damages for pain, suffering and loss of immunity payable in respect of the whiplash injury or injuries. In other words, on page 3, line 26, the phrase is injury or injuries, whereas on page 5, line 30, the phrase is simply the injury. The proposal in Government Amendment 1, recommended by Parliamentary Council, is that we deal with this discrepancy by inserting or injuries on page 5, line 30, after the injury. And I hope the opposition will be happy accepting that suggestion. Which brings us back to the central issue of the way in which tariffs are set. The Honourable Member for Hammersmith focused a great deal on the notion that these tariffs were somehow inequitable in terms of the damage that individuals have suffered. And the Honourable Member for Hyde Peak has made a number of references to the idea that we should not be referring to these types of injuries as minor injuries. We would like to emphasise that this phrase minor injuries is a phrase derived from Judicial College guidelines. It isn't a statement made by the government or any particular political party. It is simply a long-standing convention as a way of referring to injuries currently of under 2 years in relation to the Sentencing Council guidelines for those injuries of under 2 years. As Honourable and Right Honourable Members have pointed out in some of the debates we've seen, people have tried to emphasise that, of course, people suffering, particularly the longer sort of whiplash injuries, might also lose earnings, and might also have considerable medical costs, they might have to go to a physiotherapist, etc. And those arguments, while well made by the Honourable Member for Bridgend, for example, in the second reading, overlook the central fact, which is that these tariffs will only apply to general damages. So an individual who suffered loss of earnings would be able in the normal way to apply for special damages in exactly the way that you would at the moment, or an individual who needed extra care costs could apply for special damages in the way that currently exists. There is no change proposed by the government whatsoever in relation to special damages. And in relation to the arguments by the Honourable Member for Hammersmith on the level set of these tariffs, what we have attempted to achieve here is a reduction in the level of tariffs significantly at the lower end. So an individual who, for example, suffers the damage of under 3 months would be able to receive damages considerably less than currently in the guidelines. But as we approach the 2-year level, I hope the Honourable Member for Hammersmith would accept that the level of compensation offered begins to merge much more closely with the existing sentencing guidelines at a £3,600 level. In addition, of course, as the Right Honourable Member and Chairman of the Justice Select Committee has pointed out, those level of tariffs are currently proposals which the Lord Chancellor will then consult with the Lord Chief Justice, and not just consult once, but continue to consult regularly with the Lord Chief Justice on a 3-yearly basis to ensure that our calculations on pain, suffering and loss of immunity reflect the views of the judges. Pain, suffering and loss of immunity, finally, because we're really focused on this issue of general damages, it must be remembered ultimately is a very difficult judgment to make. The question of how much compensation somebody receives for loss of earnings, as the Honourable Member for Cheltenham pointed out, is something that's relatively easy to calculate because there are earnings from which that figure can be derived. The amount of money someone's entitled to, of course, for medical costs is directly derived from the cost of the medical care provided. But in the case of general damages, it is necessary for the judge to attempt to judge the subjective impact of that pain on the individual and assign a financial cost to that pain. That cannot be anything more than a subjective judgment. There is no objective scientific formula to compare pain to cash, because, of course, the cash is not designed to eliminate that pain. The cash is designed in some way to acknowledge that pain. And whether we're talking about the Criminal Injuries Compensation Scheme, where our constituents will frequently come forward to us with examples of what they will experience, quite rightly and subjectively, as a huge discrepancy between the level of horror that they have suffered at the hands of criminals and the amount of compensation offered, or in relation to the tariffs in terms of pain, suffering and loss of immunity. In the end, the compensation provided, whether by the government in relation to criminal injuries compensation or by the courts in relation to the Civil Liabilities Bill changes, cannot ultimately be anything more than a symbolic judgment whereby the court or the government acknowledges that no amount of money can remove that pain, but that the amount of money is designed to publicly acknowledge that that pain exists and provide, through a financial compensation, some recognition of that pain. If I can therefore come to a conclusion, Mr. Deputy Speaker, the President of the Supreme Court, Lord Brown, I think is an important guide on this, and his statements in the House of Lords, I think, give us all a sense of reassurance going through quite a tricky bit of law, which is that he feels 2 important principles are at stake. Firstly, that there is a moral hazard and societal issue taking place in a situation in which both the incidence of car crashes and the national comparisons with Germany and France suggest there is a disproportionate number of whiplash claims being made compared to what you would expect both in terms of automobile design and the biology of the human body, and that needs to be dealt with. In other words, fraud needs to be dealt with. But secondly, that there has been an anomaly in law where some of the graver injustices and graver injuries and sufferings have been proportionally undercompensated compared to suffering which, in the case of the minor whiplash injuries, and this is the majority of the cases coming in front of the court, are only of 3 months or 6 months in duration. On the basis of that, Mr. Deputy Speaker, if I may, I would beg leave to get the House to accept Government Amendment 1, and I would very politely request, on the basis of the number of concessions we have made throughout the process of the bill, both in the upper house and in committee stage and the lower house, particularly on the passing of savings on to consumers, that the opposition withdraws Amendment 2.
The question is that Amendment 2 be made. As many of that opinion say aye. Of the contrary, no. Aye. Division, clear the lobbies.